What I wanted to focus on is that although there's still lots of challenges, as Andy identified, in urban multiple site heat sharing networks, we do need to look into it further, and we do need to tackle some of those challenges and the disconnects I mentioned earlier. What I wanted to focus on, talking about some of the legal issues, is two types of heat network models. The first is where you have a heat network that's owned and operated by the same entity that generates and supplies to multiple sites. And the question there is to what extent they can and they should share that heat network with others who also are generating and supplying from somewhere else where it's cost effective to access that heat network, rather than build a parallel network going down the same route. The other is heat networks where it's owned and operated by somebody who doesn't generate and doesn't supply. So they're like an independent distribution network operator or an independent gas transporter. Perhaps both of those are uneconomic, and we can explore that during the course of this evening. But what I asked myself and wanted to share with you is, can you actually have those types of models? Does regulation allow it? Is it contractually doable? And I thought I'd share some of my thoughts with you. At the moment, the biggest problem that we have, in my mind, is we don't have enough regulation. And I'm not talking about regulation to make everybody's life difficult. I'm talking about regulation to actually free up some of the barriers that we're seeing, and I'll come to later on. If we look at things at an EU level, we know that the EU wants more heat sharing networks. The Renewables Energy Directive talked about this, the cogeneration talked about this. Both of them focused on encouraging use of district heating, but they don't really talk about regulating the design, build, financing and operation. And I think that's a good thing. The new Energy Efficiency Directive, which will replace the cogeneration directive, also encourages it. It sets out certain technical requirements, for example, requirements for an efficient district heating system, metering, including requirements that you have individual meters if it's reasonable, that are reasonably priced, including in high-rise or multi-flat blocks. And it sets some technical criteria when it comes to new and refurbished thermal electricity generation plants, including looking at the opportunity to find heat use or heat users from electricity generation. But it also sets some obligations on member states to carry out things like comprehensive assessments of potential for high efficiency cogeneration and district heating, to adopt policies to encourage the use of heating and cooling systems, and to carry out cost benefits analysis of district heating networks. And we know member states have had legislation for quite some time which looks very similar to regulations that you see for electricity, gas and water. So Germany regulates contractual relationships between suppliers and district heat operators, where the district heat suppliers can actually oblige customers to partly cover the cost of connecting to the system, which is what we have in electricity, water and gas. And at a federal level as well, they can also mandate connections in certain circumstances. Denmark has had a Heat Supply Act since 1979 and has similar mandatory connection arrangements. But they also regulate the behaviour of the heat market, particularly around pricing. The UK has been slightly slower to develop its policy regime. For those of you who don't know, we actually had in 1947 an obligation on the British Electricity Authority, and I'll read this verbatim from the Act, to investigate methods by which heat obtained from or in connection with generation of electricity may be used for the heating of buildings in neighbouring localities or for any other useful purpose, and the authority may accordingly conduct or assist others in conducting research into any matters relating to such methods of using heat. We established a National Heat Board in the 1970s, which looked at a number of schemes. But with North Sea discoveries, the economics of heat networks soon evaporated. We have had a resurgence in the last 4 years of government looking at heat, because they know, partly because of its commitments at an EU level, partly because of security of supply, that heat represents a massive consumption of energy. For those that haven't read it yet, I highly recommend you read the heat network sections of the March 2012 Heat Strategy Report and the summary of responses that DEC received, because what I think it does is highlight fairly comprehensively a lot of the issues that we're all facing, whether they be technical, policy, commercial, in developing a robust heat network policy framework. But that policy will take time to turn into regulation. If we're optimistic, we could say we could see something in late 2014. That could be empowering legislation. That could mean another few years before it turns into detailed regulations. The challenge, of course, that we all have as market participants is that government, in particular DEC, has quite a lot of priorities on its plate. And if everyone has views on this during the Q&A, I'd be delighted to hear it. But it's unclear to me at the moment as to how high a priority is heat, particularly given what's happened in the last few weeks with the priority on energy prices and what will come out in the electricity bill regarding electricity market reform. So at the moment, we've got fairly light touch regulation in the UK. This has its advantages for many projects that are more, I would say, site-specific heat networks. Because what it enables parties to do, it gives them flexibility in creating a commercial solution that's fit for purpose. The downside, of course, is that where you're talking about supplying an essential service on a monopolistic basis, where you don't have any regulation, then whether I'm facilitating or I'm consuming, will want to make sure I have the same protections that I would when I'm consuming electricity, gas or water. And the consequence of that means I have to replicate a lot of things you find in statute into my contracts, which I have to say is rather tedious. We also have a problem of what's driving the market at the moment. We don't really have any fiscal incentives. RHI doesn't apply to heat networks. If you look at the Ofgem Guidance Note Volume 1, it actually has a table that says equipment which is usually not included in the definition of eligible installation, and in one of the rows it says heat distribution systems. It then goes on to say later on that district heating, such as central boilers or apartment buildings, or networks of pipes delivering heat will be eligible for RHI where the heat is produced by an eligible installation. But there's no uplift for district heating installations. So if you're producing 600 kilowatts thermal of heat to one customer, it'll be treated in exactly the same way as a 600 kilowatt thermal boiler serving multiple customers. In its strategy report in March, the government did recognise, well, certainly in the responses to government, it was recognised the lack of fiscal incentives. But it's unclear how they'll respond to this. So the reality is that the primary driver for heat networks to date has been planning. We've got the National Planning Policy Framework, which encourages decentralised renewable or low carbon heat and the co-locating of potential heat customers and supplies. The London Plan, particularly Policy 5.6, also requires the development of proposals and CHP systems. And it contains a hierarchy. Ideally, it would like you to connect to an existing heating or cooling system. Its next order of priority is site-wide CHP networks, and then communal heating and cooling. But in my mind, quite a lot of concerns have been raised by planning applicants because there is a bit of a disconnect, I feel, between certain local authorities and what they view the planning obligation should be regarding heat networks, whether it be to connect to a neighbouring heat network or to extend your network to serve other sites, and what an applicant would want, which is really the ability to say, I will look into it, but I must have the ability to demonstrate, perhaps through a feasibility study, that it's not feasible, it's inefficient, it's unviable, or it's not cost effective. And we're seeing that applicants are either having to spend a disproportionate amount of time negotiating that position during the planning process, or having to agree to conditions and manage it later on. So how do I think the district heat networking market is going to develop? Well, as I say, if we want people to participate, whether that be as a heat network owner or operator, allowing access to their heat networks, to fund it, to connect to it, then we do need to address some of the barriers, ideally in regulation. And I wanted to address 3 potential barriers that I don't think can be necessarily addressed contractually. The first is to deal with the issue of what happens if an owner-operator of a heat network is in material breach or goes insolvent. If I, as a third party connecting to that system and using that system to either export my heat generation or supply customers located elsewhere, I want the comfort that I can use that asset for the life of my contractual commitments and the life of my generation asset. If the network owner went insolvent, I don't have the protections that you have for electricity, for water, for gas, particularly in electricity where you have the energy administration regime, which is specifically designed to ensure that people can continue to use this monopolistic and essential infrastructure. And I can't protect myself fully contractually. So we do need regulation. Property rights. The difficulty in dense urban environments to gain the necessary property rights to lay a heat network can in itself be the barrier for a project going ahead. It would certainly be helpful if heat network owners had similar property rights that you find in other essential utilities. And finally, competition issues. You want the ability to enter into long-term connection arrangements and use of system arrangements. You want the ability to have non-discriminatory terms. You want to know that use of system charges are being set at the right level. All of these things are currently regulated by competition law, as is electricity, gas and water. But electricity, gas and water all have bespoke competition style provisions in the relevant acts to address the more broader competition law concerns as they apply to those industries. And I think those that are in the heat market would welcome more specific regulation, competition regulation that applies to the heat market, because you're applying your factual scenario to laws that have been created specifically for your market, rather than applying your factual matrix to competition laws that are intended for every competition scenario. But we are where we are at the moment. So until there are regulations, we have to decide, well, how can we actually do this contractually? I think there are mechanisms to deal with underperformance and insolvency. You could, for example, separate owner and operator, such that if operator failed or went insolvent, then you just replace the operator. You still have the question of owner, but potentially you could create models, joint venture models. The oil and gas industry has been doing that for 40 or 50 years. If they want to build a cross-border oil or gas pipeline and they don't quite trust each other, they all become co-owners. And you have flexibility to bring new owners in. And if one of you disappears for a certain of reasons, there's mechanisms in the contract to deal with that. Query whether you could create a similar model for heat sharing networks. Similarly, use of system charges. In my mind, they're an example of where you would need either internal capabilities or outsource those capabilities to benchmark. A lot of the other concerns about standards of performance can all be contractually regulated. As I say, there are lots of examples in the market of that, and the market is developing and is mature enough that there is a sufficient critical mass of documentation out there that you can draw upon. It's just a question of time and money. My final point that I wanted to raise tonight was the role of public authorities. I think public authorities, in particular local authorities, need to do a little bit more. And I know there is a desire for many of them to do so. I think it's really important that local authorities continue to have a strong dialogue between them to share best practice, to avoid situations where a planning applicant who's pursuing multiple projects in different local regions is not coming out with different answers and different conclusions. We want local authorities to not always think it's just CHP. Now, I appreciate perhaps being a little flippant and oversimplifying there, but I do have a concern that many local authorities, when setting carbon and renewable targets, focus too much on CHP. I think we need to look at other technologies and be open to other ideas. But finally, I think local authorities need to be exemplars. Heat sharing networks in many other countries are being driven by municipalities and local authorities. There are examples in the UK of local authorities recognising actually the business opportunity. And I really welcome local authorities who are leading by example to share that with others to create a critical mass. With that in mind, I'll turn to our final speaker of the evening. Howard Mapley is the director of Inventor Partners, and I've had the pleasure of knowing Howard for over 6 years now. Howard and his organisation are a bit of a pioneers in the heat market. And Howard was a chartered surveyor for over 20 years. He's got a background in property, both public and private sector. He was the global head of internet services for Prudential's fund management business and a senior director at Stanford Research, a technology transfer company that he set up with his colleagues. Inventor Partner really focuses on innovative approaches to the provision of utility infrastructure, and Howard work focuses on particularly UK developers and local authorities. What he focuses on is kind of de-risking and finding ways to make utility projects fundable and attractive to ESCOs and investors. He's worked on the multi-utility infrastructure strategy for Exeter and East Devon Growth Point. He's working on the district energy strategy for London Borough of Sutton, and the completion of 6 ESCO deals in London over the last 12 months with clients like Land Securities, Prudential, Barratt's, Countryside, Hammerson's, Grosvenor's, and many, many others. Howard, thank you.